Hello everyone, welcome to Indian Judicial Service. In this video, we are going to solving here CBI Public Prosecutor Pre-Exam 2010. In this paper, we discuss 100 question, and in this video, we are discussing only 50 question, and remaining 50 question we will discuss in second part. And before starting this video, I request you please like and share our videos, and if you still not subscribe our channel, please subscribe it. And if anybody want the PDF file of this video series, the PDF file will be uploaded in our Telegram group as well as WhatsApp group. You may join the Telegram and WhatsApp group through the link. The link of these groups are available in our description box. Please go and join this group. So without wasting our time, let's get started. Question number 1. A complaint was received by the governor of a state and that an ex-minister in the State Council of Ministers had illegally acquired assets disproportionate to the known source of his income, and the complainant requested his permission to prosecute the ex-minister on reference from the governor to the chief minister of the state. An inquiry was held by the State Vigilance Department. After considering the report, the Council of Ministers advised the governor to refuse permission to prosecute the concerned ex-minister, and rejecting the advice of the, so in this question, the governor rejecting the advice of the Council of Ministers, the governor gives the permission for the prosecution of concerned ex-minister. With respect to this, which one of the following is correct? So answer of this question is here: governor had power to take independent decision in the matter as it related to an ex-minister. So answer here option D. Question number 2. In the interest of consumers, the parliament enact a legislation imposing certain restriction on the press, including page sealing, price and advertisements. In order to avoid any challenge to the legislation under Part 3 of the Constitution of India, the legislation was included in the 9th schedule to the Constitution. The legislation is invalid despite its inclusion in the 9th schedule, as it violate, this is very important, violate the freedom of press. So freedom of press, which is the basic feature of the Constitution of India. So answer of this question is here option C. Now question number 3. Which one of the following interpretation of section 376V of the Indian Penal Code did the Supreme Court of India hold the case of Omkar Prasad Verma versus State of Madhya Pradesh? Answer of this question is here option A. The term custody imply the guardianship and its meaning also including care, keeping, charge, imprisonment, judicial or penal, safekeeping, etc. So answer here option A. Now question number 4. In which one of the following cases did the Supreme Court hold that in appropriate cases the police officer have a duty to conduct a parliamentary inquiry before registering an FIR in order to find out whether allegation made have any substance or not? So answer of this question is here option C. Rajendra Singh Kote versus Chandigarh administration. Now question number 5. The confessional statements are made by the conspirators after they were arrested, implicating other co-accused as co-conspirators. As regard the admissibility of the statement, which one of the following is correct? So answer of this question is option C. The statement is inadmissible because the common intention was no longer in the existence as hold in the parliament attack case. So answer here option C. Now question number 6. By which one of the following act does Information Technology Act allow any subscriber, this is very important word, any subscriber to authenticate an electronic record. So answer of this question is here option A, by affixing his digital signature or by reliable electronic signature or electronic authentication techniques. Now question number 7. For the conduct of any inquiry or investigation into any offence committed by the employee of the central government of the level of joint secretary and above under the provision of the Prevention of Corruption Act 1988, the Delhi Special Police Establishment must take prior approval of the central government. So answer here option A. Question number 8. Which among the following amount to criminal misconduct by a public servant under the Prevention of Corruption Act? Option A, habitually abstaining from a regular duty without permission of the superior. Option B, being in possession of pecuniary resources or property disproportionate to his known source of income. Yes, this is related to Prevention of Corruption Act. Now option C, point 3, the negligently render the government property to be damaged and destroy. So only 2 is related here. So answer of this question is here option C. Now question number 9. Under which one of the following ground can be the Central Vigilance Commissioner? This is very important. The Central Vigilance Commissioner can be removed from his office. So under which ground? So on option A, the prove the misbehavior or incapacity. Yes, it is a proper ground of removal of Central Vigilance Commissioner. Option B, engaging in any paid employment outside the duty of his office. Yes, this is also proper ground. Now option C, when adjudged and insolvent. So all these grounds are related to the removal of the Central Vigilance Commissioner. So all of these. So answer here any, on any or all of these charges. So answer here option D. Now question number 10. Which one of the following rights is not available to an accused and delinquent person? So answer of this question option B, to refuse to give specimen signature and sample of writing. So answer here option B. Now question number 11. The Parliament has no power to make law on. So option A, audit of account of the union and of the states. Yes, in this matter the Parliament has power to make law. Option B, the taxes on advertisements published in newspaper. In this matter the Parliament has no power to make law. So answer of this question is here option B. And remaining, prevention of cruelty to animal and duty of exercise on of him. So in this matter the Parliament have right to make law. So answer here option B. Now question number 12. X instigate Y to murder Z. Y refused to do so. X is guilty of. So X is guilty of abetting Y to commit murder. So answer here option A. Now question number 13. When an accused person is pardoned under section 306 of the Code of Criminal Procedure 1973, he become a witness for the prosecution. So answer here option A. Now question number 14. In which one of the following cases was the constitutional validity under section 27 of the Indian Evidence Act upheld? So in which case? In case of State of Uttar Pradesh versus Devman Upadhyay. So answer here option A. Question number 15. Under the Information Technology Act, when an electronic record attributed to the originator. Option A, when it is sent by the originator himself. Yes, this is correct here. Option point 2 here, when the information system programmed by originator send electronic record automatically. Point 3, when electronic record is sent by a person who had authority to act on behalf of the originator. So all these statements are correct here. So answer of this question is here option D, 1, 2 and 3. Now question number 16. The superintendent of the Delhi Special Police Establishment relating to the investigation of offences committed under the Prevention of Corruption Act Cell 1988 cell vast in the Central Vigilance Commission. So answer is here option A. Now question number 17. When can the court take cognizance of the offences punishable under the Prevention of Corruption Act? So answer of this question is here option A, with the prior sanction of the central oblique state government. Now question number 18. Which one of the following statements is correct? The LB under section 11 of the Indian Evidence Act 1872 is decided on the basis of preponderance of. So answer of this question is here option B, the probability beyond all reasonable doubt. So answer here option B. In some books there is the answer option A, probability. So it may be, but most suitable answer is here option B. Question number 19. Consider the following. By notification issues by the central government, seats were directed to the B reservation in central government's educational institution for various category of candidates. Thus, scheduled caste 15%, scheduled tribe 7.5%, OBC 27%, physically challenged person 3%, and 5% for sports, and children and wards of army forces persons 5%. So including of all these reservation, it exceeding the limit of 50% reservation which was given by the Supreme Court in case of Mandal Commission, means Indira Sahni case. So this type of reservation is invalid and unconstitutional. So in relation to the above, which one of the following statement is correct? So answer of this question is here option B, the reservation are invalid as the total reservation exceeding 50%. So answer here option B. Now question number 20. 5 civil servants were dismissed from service without any inquiry or hearing for their conduct of assaulting their boss at the railway station immediately after his retirement. The reason for dismissal including impracticability of holding inquiry were duly recorded, and it was proved that the assault took place in a planned manner. All of them were arrested and prosecuted for assaulting the boss, but later and acquitted, this is very important, by the criminal court. In this respect, which one of the following is correct? So clearly the dismissal without inquiry and hearing is not valid. So answer of this question is here option A. Now question number 21. Which of the following are included as the cruelty and under section 498A of the Indian Penal Code? Option A here, willful conduct likely to drive the woman to commit suicide. Yes, it is appropriate and relevant to section 498A. Point 2 here, willful conduct likely to cause grave injury to life, limb or health of the woman. Point 3 here, harassment with a view to coerce her to meet any unlawful demand of dowry. So all these three statements are relevant. So answer of this question is here option A, 1, 2 and 3. Now question number 22. In the case of Inder Mohan Goswami and another versus state of Uttaranchal and other, the Supreme Court held that non-bailable warrant should be issued only when the summon or bailable warrant would be unlikely to have the desired result of bringing a person to court. So answer of this question is here option A. Now question number 23. A statement to become relevant under section 32 subsection 1 of the Indian Evidence Act as dying declaration should have been made under which of the following circumstances? So option A, it should have been made in relation to the succession of his property after his death. So it is wrong here. It is not relevant under section 32 clause 1, which is related to dying declaration. Option B, it should have been made under the imminent expectation of death. And option C here, it should be in relation to the very important word cause of his death or circumstances. This is very important word, circumstances of the transaction that result in his death. So clearly answer here option C. And remaining option D, it should have been made in the will of executed by him. So it is not relevant. So answer here option C. Now question number 24. What do we understand by key pair under the Information Technology Act? So key pair is, it is a private key and it's mathematically related to public key. So these are the key pair. Answer here option C. Now question number 25. The offences punishable under the Prevention of Corruption Act can be tried by a special judge appointed under the Prevention of Corruption Act. So answer here option B. Now question number 26. The committee recommending the appointment of the Central Vigilance Commissioner consists of Prime Minister, means PM, and Union Home Minister, and the leader of the opposition. This is very important here, in the House of People. So answer here option B. Now question number 27. Which one of the following statements is correct? So correct statement here: no person can be subject to narco analysis test against his and her wish. So answer here option A. Question number 28. The Supreme Court in a public interest litigation, means PIL, issues direction to the central government to give statutory status to an organization. The central government failed to give effect to the said direction of the court. The petitioner filed a contempt petition before the Supreme Court. In respect to above, which one of the following is correct? Option A here: the central government is guilty of contempt of court of its inability to give effect to the direction. So this statement is wrong here. Central government is not guilty because it is the discretionary power of central government. Option B: the central government is not guilty of committing any contempt of court, as the direction issued by the court were beyond its jurisdiction, as the making of law by parliament was a matter of its discretion. Option C here: the central government is not guilty of committing any contempt, as the direction were violative of separation of power theory. So both first and fourth, B and C option is correct here. So answer of this question is here option D. Both statement B and C together describe the law correctly. Now question number 29. In the crime of adultery, the wife is not punishable. So answer here option C. Question number 30. In the context of section 378 subsection 4 of the Code of Criminal Procedure, the Karnataka High Court in Sarojamma Hochgondar versus Eswarappa held that the right under the provision of a personal right and can be exercised only by the complainant and not by her legal representative. So answer of this question is here option A. Question number 31. The evidence are adduced by the party to the suit about the character as per the provision of the Indian Evidence Act. Which of the following is are correct? So point 1 here, evidence of the character in civil proceeding is irrelevant and inadmissible generally. Yes, this statement is correct here. Point 2, the character evidence is admissible if it is affect the amount of damages which is ought to be received. Yes, this statement is also correct here. Now point 3, the character evidence is admissible in so far as such character appear from fact otherwise relevant. So answer of this question is here only first and second statement correct. So option B. Now question number 32. What does identity theft for which punishment is provided under the Information Technology Act mean? So punishment here, fraudulently and dishonesty, making use of the electronic signature, password or other unique identification of other persons. So answer of this question is here option B. Now question number 33. Consider the following statements regarding the appointment of a director under the Delhi Special Police Establishment Act 1946. So point 1 here, the committee appointing a director shall consist of Central Vigilance Commissioner as its chairperson. Point 2 here, the committee shall recommended a panel of officers on the basis of seniority, integrity and experience in the investigation of anti-corruption case. So this statement is correct here. So first statement and second statement both are here correct. So answer of this question is here option B, 1 and 2 only. Now question number 34. In a charge for the offence of taking gratification by public servant under the Prevention of Corruption Act. So answer of this question is here option B. The prosecution will be having the burden of proving the fact of accepting the gratification as well as the fact that it was received as a motive or reward for doing or forbearing from doing any official act. Now question number 35. A Central Vigilance Commission. So Central Vigilance Commission does not have power to direct the Delhi Special Police Establishment to conduct its investigation in a particular manner. So answer of here this question option C. Question number 36. A state government granted licenses to a certain private operator to run stage the carriages and contract carriages. The stage carriages could run only from one fixed point to another with fixed passenger without any right to pick up the passenger en route. No such restriction were imposed on contract carriages that were required to pay higher rate of tax than stage carriage operators. The contract carriage operators challenge the discriminatory nature of tax imposed on them. In respect of the above, which one of the following is correct? So which one is correct? So the option B is correct here. The tax is valid. There is reasonable classification between stage carriage and contract carriage in view of the fact stated above. So answer here option B. Now question number 37. In which one of the following cases A and B be held guilty of criminal conspiracy even if no act is done by them? So answer of this question is here they are held for guilty of criminal conspiracy. So answer of this question is here option B. A and B agree to commit an offense. So answer here option B. Now question number 38. The Supreme Court of India in the case of Navjot Singh Sidhu held that, so in case of Navjot Singh Sidhu held that only a sentence can be suspended using section 389 of the Code of Criminal Procedure, but the petitioner need to specifically draw the attention of the court to the consequences that may arise if the sentence is not suspended. Now question number 39. The Supreme Court in Salvi and other versus State of Karnataka held that the compulsory administration of narco analysis technique amount to testimonial compulsion, and thereby that triggers the protection of Article 20 Clause 3 of the Indian Constitution. So answer here option B. Question number 40. Under the Information Technology Act, point 1, intermediary is not liable for any third party information if its function is limited to providing access to a communication system. So this statement is correct here. Now second statement, the intermediary is not liable if it does not initiate the transmission, does not select receiver, and does not select information. So this statement also correct here. For first and second both statements are correct. Now third one, the intermediary is not liable if he adds or induced the third party to commit unlawful act. So this statement is absolutely wrong. So first and second statement is correct. So which of the statements given above is or are correct? So clearly first and second only. So answer here option B. Now question number 41. Which of the following is are correct under the provision of the Prevention of Corruption Act pertaining to calling an accused as competent witness? So point 1 here, he can be called as witness at his own request. Here this statement is correct here. Now statement 2, his failure to give evidence will not give rise to any presumption against them. So this statement also correct here. Now third one, he can call as witness only when he is on bail. Select the correct answer using the code given below. So this statement is not correct. Only first and second statement correct. So answer of this question is here option B, 1 and 2 only. Now question number 42. Which of the following statement is are correct? Point 1 here, the President shall cause the report of Central Vigilance Commissioner to be laid before each House of Parliament. Point 2 here, Central Vigilance Commission is duty to bound to present to the President a report as to the work done annually. So both statements are correct here. So answer here option C, both 1 and 2. Now question number 43. Under Article 74 of the Constitution of India, there shall be a Council of Ministers to aid and advise the President, who shall act in accordance with such advice. In which of the following case the President is not bound, this is very important here, not bound by the advice of the Council of Ministers? So in which matter? So first one, dismissal of a civil servant in the interest of security of state. In this matter, President is bound to getting advice from the Council of Ministers. So this is not our answer. Option B, the dismissal of state government for failure of constitutional machinery in the state. In this matter, the President is bound to getting the advice from Council of Ministers in center. Now point 3, option C, The promulgation of an ordinance when both House of Parliament are not in session. In this matter, the President is bound to getting advice from Council of Ministers. Now last one, while deciding a question regarding a disqualification of a member of Parliament. In this matter, President is not bound to get advice, to follow the advice of Council of Ministers. So answer of this question is here option D. Now question number 44. A, with a certain criminal intention, abet B to commit an offence. The B commits the said offence but with a different guilty mind. Which one of the following is the correct legal position? So clearly answer of this question is here A is liable. A is liable as abettor. Answer here option C. Now question number 45. If an accused pleads guilty, the judge, so in this case the judge has the discretion to convict him after recording his plea. So answer here option C. Now question number 46. Under the Indian Evidence Act, which one of the following is correct? So clearly the judge has power to ask any question to the party witnesses on any fact relevant to the case. So this statement is absolutely correct here. Answer option C. Question number 47. In cases where a document proved to be 30 years old is produced from proper custody, which of the following presumption will the court makes? So court makes the presumption of, the court may presume that the signature and handwriting is the signature and handwriting of the person to be and was duly executed and attested. So answer here option C. Now question number 48. Information Technology Act has been given overriding effect on other laws in force except. So first of all, Information Technology Act has been overriding effect on other laws. So in other laws, the right of any person under Copyright Act or in Patents Act, in this case the Information Technology Act has been given override effect. And second here, the right of any person under the Prevention of Corruption Act, in this case the Information Technology Act override it. And now option C, the law governing the geographical indicators, in this case the Information Technology Act has been given overriding effect. But in option D, the right under the Negotiable Instrument Act, the Information Technology Act has been not overriding in this case of the Negotiable Instrument Act. So answer of this question is here option D. Now question number 49. Consider the following statement regarding the provision of the Delhi Special Police Establishment Act 1946. So first option here, point 1, the special police enforcement established under the act is empowered to investigate all offences under the Police Act 1861. So this statement is wrong here. Now point 2, the special police force is a separate and independent body from that create under the Police Act 1861. So it is also wrong, it is not an independent body. So both statements are wrong here. So answer here neither A, neither 1 nor 2. So answer here option D. Now final question of this video, question number 50. The principal's secretary purchasing a house for a meager amount, this is very important, from one of the parties to a proceeding that was disposed by him in favor of that party can be tried under. So can be tried under. So under section 12 of the Prevention of Corruption Act only. So answer here option C. So now we are going to finish this video, and if you like this video, please click on like button, and if you still not subscribe our channel, please subscribe it, and please press bell icon button which will provide you a further notification of our videos. Thank you for watching Indian Judicial Service.